In the first 5 chapters, it really brings to the forefront an important debate on privacy today, which is how do we adapt and modify our current privacy laws to ensure that people can enjoy the convenience and benefits that come from research in a digital age without forfeiting privacy. There's a lot of dimensions currently running in this debate on privacy versus big data research. One dimension will say that there is no expectation of privacy when a person gives their information to a third party, like your phone number to the telephone company. Then another group would argue that we should distinguish between the kind of information that we give to private companies versus the kind of information the government gets. And then, from, of course, the government's point of view, we see this in the European Union and across North America, is that, I'm going to quote Toomas Ilves, president of Estonia, when he spoke at MIT in September 2013, and he said, "Don't fear Big Brother. You need to worry about Little Sister, private corporations that know everything about you and tell everyone." So in this first section of the book, the authors do a really good job of bringing together and addressing a lot of these arguments, and of course others that center around protecting privacy, but also how can we modify privacy laws to expand research in a big data environment. And one common theme running throughout this is that the current framework, legal framework, is inadequate and ineffective really for the kind of research that needs to move forward in the digital age. So in the first chapter, and I'll just briefly summarize so you can kind of see how they all relate to one another, as why they clustered the first 5 chapters together. Because in the beginning, in chapter 1, the author provides a nice overview and taxonomy for the current privacy laws. You have privacy laws that are based on some rule-specific regulations like HIPAA, and then you have other privacy laws that are going to apply specific facts to certain identified criteria and identifying what's inside of the privacy zone. I think a couple concepts the author tosses out, which will develop, is digitization versus datafication. Because whether you have video streaming or audio recordings, this gets digitized. But it's not until that information gets put into a computational format, which now makes it useful for research. And that's what provides the challenge to the privacy laws when you expand all these open uses for the information, basically making digital information more useful. A lot of several recommendations the author puts forward in concluding on how we could balance the trade-offs with privacy and expanding access, and I'll let her address those. And then in the second chapter, we see, again, that common theme that the basic tools we're all working with in the privacy area of notice and informed consent just aren't going to work well. You have basically an environment for observing a lot of behavior and coming up with correlations that people just aren't able to give an informed consent about, because researchers don't even know about these correlations until they're getting access to the data. And then really one concept that author develops is this contextual integrity, that it's the social context in which the research is being conducted that really presents the challenge to the privacy laws. And I think in the next chapter, segueing in, as the previous speaker mentioned, the author does a good job of writing a cost-benefit analysis to privacy and how it affects research. I think any regulations and rules, he points out, and it's sort of like the Richard Posner type of argument, economics of law, where you're going to put in basically a landscape that's going to lower the long-run operating costs for all the businesses when you have the privacy protections in place. But conversely, these kind of same laws can create obstacles for, again, either economic activity or, in this case, as he points out, certain research activity. I think one concept he develops later on in the chapter is the privacy paradox, in which consumers through numerous polls and surveys, we'll talk about how people do want privacy, but they're just really not willing to pay for it. And I think, as Julia mentioned, the discounts you get at the grocery store when you swipe your card. We're almost operating now in an age that if you really want privacy, it's almost a luxury for the wealthy. And so that's why we're looking at, you want to call for an adaptation of privacy laws to extend the same privacy benefits to the average person and the general public. Chapter 4 is a great chapter. I love some of the recommendations he develops in there. Once again, Paul Ohm's written several times on this concept, or the discussion that the privacy laws really need to be changed, because the whole element of, what are the risks? And privacy boards, IRBs, we're all looking at what's the risk of identifiability and, those kind of specific harms. And he says, no, it's time for the paradigm shift, because the risk of harm is not really as much to the individual as to groups of people in society. When you have groups that could possibly be harmed because decision-making is being made on algorithms that identify correlations. So whether your mortgage loans are going to get denied because you fit a certain profile, whether someone is eligible or not for parole, what's the probability of violating parole, what's the probability of committing a domestic violence incident, let's fashion a final decree a certain way in divorce order. So now, when decision-making is being based on algorithms, the harm is more to classes and groups of people in society. And to that, I think he's got he's got a lot of good recommendations. One of them, it's probably coming in near future or in the next 10 years, that we need to abandon this distinction between PII, personally identified information, and non-PII. It's just a nightmare right now when you're reviewing research protocols on privacy boards to struggle with what's PII and when he can say a data set's anonymous. And finally, in the fifth chapter, which closes this section of the book, the author really develops kind of two counterbalancing principles. One in which they're trying to basically set a certain threshold that these legal encumbrances in the patent and copyright field present for sharing of code, sharing of data, in which case, I think in a big data environment, the code is as important as the data itself. If you're looking at reproducibility of results and data quality checks, and at the same time, what can we do and mechanisms for expanding researcher access? And she offers some good recommendations on that. So in the panel this morning, and I'll turn it over, they're going to present their work in much greater detail, but relating it in the broader context of this debate of what can we do to now modify laws to protect privacy while at the same point expanding data access for research activity. So I'd like to turn it over now to Kathy.
Thank you. In my chapter, one of the things I tried to do, which I'm not really going to talk about here, but I want to just mention for people who might want to read it, is I was asked to talk about the law and privacy on the collection of data. And so one of the things I really tried to do in the chapter was just to present an overview, which had to be very general and so forth, of what the law is. As I said, that had to be very general, otherwise it would not have been one chapter. But in doing that, I was really trying to write this for people who are not lawyers, to try to give you some kind of a way of thinking about it. And that was kind of the purpose of the taxonomy, of thinking about what the law is like in this area. So I hope that that will be useful for people, although I'm not going to talk about that here in the limited time that I have available. So what I want to talk about here instead of focusing on individual things about various laws, is sort of the issue that we've been talking about all along so far of how the current privacy law is really not well suited for today's issues with big data. And I think if we think back and look at how the law developed, we can understand this. I think privacy law was designed primarily for certain kinds of contextual paradigms. And I want to point out three that I think were the main ones. So the first one was the regulation of spying and monitoring and intrusion into private matters and private places. So there's a whole strand of law that deals with that. Examples of that being something called the intrusion upon seclusion tort, something people might be more familiar with, especially in light of a lot of revelations we've been having recently about government spying, the Wiretap Act, which we mostly think of as an act that tells us when government can tap phone calls. But what it is from a privacy law perspective, first and foremost, is a law that tells you that the rest of us can't tap phone calls. And that was a real serious question back at the time when that act was first passed. So the spying and monitoring intrusion, very targeted, that is one context. Another context that the privacy law comes from is the context of sensitive information that is disclosed to people who are in some kind of professional or fiduciary, in a sort of rough, maybe not legal meaning of that term, relationship. So doctors, bankers, that kind of situation. And in that situation where you have information disclosed to these kinds of people for particular purposes of getting their assistance, a lot of our law developed from that paradigm. So, and that paradigm is very strongly focused on notice and consent, which Helen will talk about. And that's kind of law like the Health Information Portability and Administration Act, the Financial Privacy Acts, confidentiality torts, and so forth. And then the third paradigm is research. But here we're thinking mostly about medical research in the context of a relationship with somebody like a physician. And there we have the IABs, we have Health and Human Services regulation, and so forth. So these are the contexts that sort of that spawned our privacy law, I think, primarily. Then we kind of added on to that in around the 70s. The idea that, wow, government is collecting all this kind of information in terms of providing services through various kinds of government agencies. And that's where the fair information practice principles sort of came up in that scenario. So again, there we had a sort of individualized, we're collecting this data for one purpose, and then we're sort of going to wonder about how we can handle it and when we can collect it. All of the privacy law that we have now on the books grew up out of these contexts, and for that reason has a very individualized notion of the kinds of harms that we're trying to protect against. And this is something I already mentioned in terms of talking about Paul Ohm's chapter. So a very individualized perspective on harms and a very individualized perspective on collections. As was already mentioned, there's almost no regulation of use or, in the US at least, of repurposing, except in a few of contexts, these sort of confidential fiduciary type contexts. And because of this also, there's an assumption that the trade-offs that you're talking about between privacy and whatever benefits you get from disclosing data and collecting data are also fairly individualized. So again, not dealing very well with collective harms and benefits, and really very little need for a focus on privacy trade-offs with what are you doing with the data and how effective is it and what is it for, except maybe in the research context. So that's where the privacy law came from. What is privacy law not designed to deal well with? A lot of what is going on right now. So in particular, privacy law is really not at all well designed to deal with information that is obtained by a service provider as a byproduct of providing the service. So there is not in the privacy law a really good differentiation or concept between information that is the information you're collecting and using and information that's just sort of there and that you collect as a byproduct of providing the service. And one of the things I argue in the chapter is that that is an important distinction that we should be focusing on more, especially when information is collected and used for purposes beyond providing the service. Which now is happening all of the time, and most evidently in the area of using information for behavioral advertising. The other thing that privacy law is not designed to deal well with is, and this has been mentioned before too, aggregation of information from many sources and aggregation of information over long periods of time. The sort of underlying assumption behind most of the law is fairly one-off collection of data. And then finally, the information that's being saved in a sort of datafied form that can be used for purposes of data mining and prediction, purposes that are really not at all contemplated at the time of the collection, and also for important decision-making affecting individuals that's not within the original purpose of the collection. So attempting to stretch current privacy laws to deal with big data, which deals, of course, raises all of these issues, have really been pretty difficult, and I would agree with Paul Ohm, pretty unsatisfactory. I don't have any, silver bullets for figuring out what to do going forward. I think we really have to do a lot of research and thinking about this. But I do make in the chapter a few suggestions of ways to move forward, and I'll just mention a couple of them here. One, I think, might be obvious from what I've already said, which I think is that it's really important in thinking about privacy regulation to start separating out different kinds of uses. Government use from private use, research use from, for example, advertising use, and so forth. Something that we've done only in a few areas, but I think we need to do more generally. I think we need to distinguish information that is acquired as a byproduct of providing a service from information that you can get at because you're providing the service, but is not really required or used in providing the service. So a sort of non-big data example of that would be there's a difference between the repair person coming in to repair your refrigerator and the information they learned about you from looking at the refrigerator, and the information they might look at by sort of looking around to see what else they can see in your house while they happen to be there fixing the refrigerator. We haven't been making that kind of distinction. I think we need to. And then finally, I think one of the things that we need to start doing, and there are a few people who've been thinking along these lines, is trying to think about regulating the use of big data and the collection of big data, trying to learn from other kinds of regulatory paradigms that we've had in areas where we've had to deal with aggregated harms, probabilistic harms, very interlocked consequences of people's behavior, such as the environmental area and the toxic tort area and so forth. And we haven't really had much sort of feedback or conversations between these different areas of law, and I think we need to start having those conversations. So I'll stop there.
And so next we'd like to hear from Helen Nissenbaum.
It's a good spot to pick up from Kathy's presentation because Kathy laid out many of the problems, and I'm going to look at some of the solutions. Oh, this clicker works. Yes. Okay. So here we are, big data. All of us want to make the best use of it. We also are concerned about some of the downsides, in particular losses of privacy. I have to keep track of time. All right. Now, standard solutions, the standard go-to solutions that many of us are aware of. Oh, let me just, sorry, this is something that I meant to mention, which is, and it's really important, is that this is a co-authored paper, and my co-author, Solon Barocas, is sitting over there, so if you have any tough questions, that's the person who's going to answer them. So the standard solution to many privacy problems that we confront, and of course many of the gaps that the law leaves open, are, look, we can do this. We can do this by, first of all, anonymizing the data that we have, and that's going to mitigate many of the harms that we're concerned about. And also what anonymization does is that it takes the data out of the remit of privacy, so that if you look at for example, the 1973 report that the Department of Health and Human Services commissioned, they said, here's statistical data and here is identifiable data, and we have different rules for dealing with them. And then when you do have to have data that's identifiable, then informed consent is the way to go, because it respects individual autonomy, individuals' right to choose. And so it says that the privacy problems, if you deal with them in this way, you have two sorts of problems, that practical problems you need to deal with. One is, how do you anonymize effectively? That's one problem for anonymization. And the other one is, how do you operationalize informed consent? Because this has, in many of the arenas where big data is assembled, where we're getting data from, is from the online environment. And how do you operationalize informed consent when you're just clicking away online? Now, this is, if I don't manage to present everything, here are the main theses of this article. One is, anonymity is not enough, and the other is consent is irrelevant. In other words, these two strategies, which are the cornerstone of privacy protection, are utterly undermined in a big data environment. So why so? Now, I'm not going to say everything on these slides, but I'm assuming you can read away while I'm going through them. First of all, many of us who are in the field know that there are all sorts of challenges to anonymization, triangulation, sparse sets, many of the recent, say within the past decade, re-identification attacks. And some of the solutions that are being offered are statistical, mathematical, cryptographic in their character. We aggregate the data so that we don't have, it's not obvious that that a single user pops out of it. Solutions like LaTanya Sweeney's K-anonymity, differential privacy, and so forth. Now, when you take a step back, you say, why do we care about anonymity in the first place? Because if we think in traditional terms, anonymity is namelessness. Why do we think it's important? Some of the reasons why we value anonymity, why we think it's important, is that it's not so much that we think namelessness is a value in and of itself, but all those harms that we're concerned about, the fact that we can reach, that we can affect people's lives, that we can protect whistleblowers, that we can protect children, that this allows freedom to study and research and be creative, that it enables certain zones of our lives, like going to the library and taking a book out, where we don't have to be answerable to any authorities. This is why anonymity is important. Now, but the problem with big data is that with a lot of data is that it doesn't matter that they don't know my name. Because there is so much data out there, even if the data doesn't identify me as Helen Nissenbaum, I can go online and be affected by this data, be systematically affected by the data, whether or not they know my name. And in fact, as you see over here, and this is a quote, some of the big data aggregators out there say, in fact, we don't want your name. Your name is just noise. What we want to do is assemble a lot of data about you, cluster you, profile you, and in that sense, anonymity or anonymization, even if it is successfully performed, is not going to protect you against differential treatment, against discrimination, some of the concerns that we have in the first place. And in particular, one of the concerns is that you can be a conscientious researcher, and when you go in to the IRB, you say, we're going to conduct research on depressed students. We promise we're not going to identify any of the students. And what we find is that their online usage is different from non-depressed students. You publish that result, and now other colleges can observe students' behavior and be able to infer from these results to identifiable individuals. And so you can go from anonymized data to identify specific individuals based on that anonymized data. So the conclusion we reach is not that anonymity is really, really difficult. Well, it is really, really difficult, but that's not the main problem. Even if we could achieve it, it's not a value anymore, because the value of anonymity can no longer be sustained, even if anonymity can be. Now, in the area of informed consent, we also have a lot of problems that many people have been working in the field. Many social scientists have observed that, especially in the online arena, informed consent hasn't worked. Privacy policies are impossible to understand. They're poorly implemented. And in fact, it's also very difficult for organizations who need to contrive very, very thorough privacy policies that say absolutely everything. Now, the aggregation of data increases the burdens of informing people by orders of magnitude. And I'm not going to go through everything over here, but here is why the fact that, and many of us have already mentioned, what you can infer from the data is unpredictable. Data moves around very rapidly. And so this highly complex data environment is virtually impossible to explain to individuals. And so many people who work in this area say, no, we can still save consent. We can simplify. We can have something like a nutritional label so that people can just read the notice and comprehend it. Some of the argument that we've offered in previous work says that, and we call it a transparency paradox, but maybe it's a dilemma, you can't have it all. Either it's going to be comprehensible or it's going to be comprehensive. And if it's comprehensible, you are not going to be able to be telling individuals what they actually really need to know in order to make a decision whether to supply information or agree for the information to be in a database and allow access to information. But the heart of the argument in this chapter is different. It once again says that you can have the capacity to consent or not. And let's say organizations accept the fact that you agree or not agree to have your data enter into their database. The problem is that whether or not you consent, a lot can be inferred about you just by your, first of all, what other people say about you, or what can be inferred by information that others reveal, and second of all, implicitly, in a passive way, simply by being part of a social network. And I think the MIT study on gaydar was one example of that. And then finally, something that we call tyranny of the minority, which is that in many studies, and this is a characteristic of big data, of the big data paradigm specifically, you only need a representative, you only need information from a representative sample, and from other individuals, you need just some data, and based on your knowledge of what's in based on what others from this representative sample have revealed to you, you can draw inferences about the wider set of individuals who may not have given their consent. And so whether or not, in the Target case, you happen to have agreed to tell Target that you were pregnant, Targets can still infer that you are pregnant based on the habits that they've been able to infer about others, and the fact that others have, a small minority have revealed to Target. So some people will say consent is difficult. We say consent is irrelevant. I'm actually, what time did I start? Have I been about 10 minutes already?
Yeah.
Okay. So that's a good thing, because I'm not going to tell you what the solution is, even though I really do. But many people will say, oh, my goodness, yes, we agree with you. Consent anonymity are really problematic. Therefore, this just shows that privacy and big data are incompatible, and we have to make the trade-offs. Clearly, the value outweighs the costs, and so goodbye privacy. And we've seen many in the literature who have tried to make this argument. Our argument is that, first of all, this thoroughly confuses means with ends. We need to set aside anonymization and consent and relegate them to some small corner. Yes, they are important, but no, they're not going to solve our problems. And we think that, in fact, this big data argument that we're having right now is an opportunity not only to address these problems, but also going forward to address some of the problems that privacy theorists have grappled with for a long time. And we think that we have lessons to learn from the biomedical sciences, and perhaps these solutions will crop up in discussion. But otherwise, I'd love you to read our article and get your reaction. Thank you.
In Helen's chapter, she has several other recommendations. I think it's a wonderful advertising technique to kind of toss it out there, then hold back the final few to bring it in. Next, we'll have Victoria Stodden present to us from her chapter.
Okay, well, thank you, Jake, and thank you everyone for coming out so early, actually, on Monday morning. So my chapter is actually what I'd like to say to you has been beautifully set up by both Kathy and Helen, and I'm very lucky actually to go in the last position. What I tried to do in my chapter was really scope this issue to research on big data, particularly how do we know that we can trust these inferences and we have reliable information, actionable knowledge coming out of these sort of very enormous data sets or very complicated data sets that characterize big data. And this is something that I think is non-trivial, because one of the cornerstones of doing good research is that we have others checking our work and verifying this, following through our logic and saying, yeah, maybe you missed something here, or, you know, I actually really agree with what you did, and I can see how you got those results. And so this comes into conflict with restrictions placed on data that could arise from things like privacy and so on. And one of the themes that runs throughout the book and is running throughout the conference today is that managing this privacy, aside from the fact that this is legally mandated in many cases, is something desirable. And so how do we balance these sort of the exigencies of privacy and subject protection in big data research with the need for openness, transparency, reproducibility, and traditional ways that scientific investigations have been made to be more reliable and well-founded and trustable. And traditionally, this is yet another example of how the law that we've inherited around this was built on a smaller case. Our tradition is in institutional review boards and ensuring that any subjects in data, like in an experiment, Helen mentioned if you have students who are depressed or not depressed and so on, and in her talk, in trying to make sure that no harm is visited upon people who are participating in research. And so right away, given the hour or so of discussion that we've had this morning, you can see that this is at odds with data that's not necessarily purposefully collected for the research itself, right? It's one thing to have a study where you're going to go and survey people, and perhaps you can sit down with them and have a discussion or about consent and so on, and about the study, and perhaps you can in some sense protect them. It's a very different environment when you have big data that's already been collected. Maybe you may or may not fully understand how it was collected. There are subjects in there. You can mix this with other data sets that also have subjects. You don't really have a way of contacting these people. So how do we ensure some level of protection? And how do we ensure that we can actually reproduce this work independently, or have other researchers go ahead and verify the work that's been done and the research that's been done, especially if we're basing policy decisions on this and other conclusions. And and the whole point of big data is we're supposed to be able to do better inference and learn more about the world we live in and make better decisions. So I think this poses an interesting dilemma. I'm not the only one that noticed this. So all these articles are from these are just a smattering just from the last year. I think the last 12 months. People here noticed that in October of last year, The Economist had a special issue, How Science Goes Wrong. LA Times is saying that scientists, we've lost our way at a big cost to humanity. And then you can see also Science and Nature, these very high impact journals in scientific publishing, talking about problems that they're having with reproducibility of what they're actually publishing. Now, there are many causes for this. Some to do with reporting standards and so on, but one of them is how do you access the data? And as Jake mentioned in the introduction, how do you access the code that produced those results? So it's one thing to have the data set. It's a very different thing to also have the knowledge that's been extracted from the data set if you don't have those steps in between. And so I am going to give you a spoiler and give you the recommendation in the chapter. In thinking about it as a gold standard, putting aside privacy issues for a moment, it would be really wonderful to have access to the data that your study was based on and have access to all those steps, the computational steps that produced any computational findings that you've done. I would understand things like how did you merge those two data sets? How did you deal with outliers? What did you do with records that sort of seemed to match but didn't really, but maybe it really was the same person and so you just sort of put them together. And all these things that are messy and that definitely arise when you're trying to work with any data, but especially big data. And then also in analysis and inference, what models have you applied? How did you handle errors? What were your confidence limits and so on? And did you do all this correctly? And at least can I understand? Without all that information, it's very difficult for us to make sense of the output from the analysis on big data. So this is what underlies some of this. Let's get access to data. Let's get access to code. Now, of course, that sounds terrific until you run into our main theme today, which is lots of data we can't just throw out there for a variety of different reasons. Some of them we just legally can't give everybody access to data based in those models, the old IRB models of protecting subjects who are in scientific investigations. Okay, so what I wanted to do in the chapter was say, okay, so this is something for us to start thinking about and being creative about. As Julia mentioned at the very early, in the first comment actually of the day, one of the driving reasons for the book is that if we start to realize and think about privacy concerns in big data and possible harms, the instinct, and this is in the paradigms that we already have and the mechanisms we already have around data, the instinct is to shut down the access and to protect folks. And this, in my interactions with IRBs at various institutions, this is the mindset. And you can see that this makes a lot of sense. It's hard to fault an IRB that says subjects need to be protected. If you're going to carry out a study on them, we need to make sure they're not going to be hurt in the course of the study. As Helen mentioned and other folks are mentioning, it's really difficult now with big data to quantify what this is, and these are data that we didn't even collect and we don't necessarily understand their generation mechanisms. So in trying to get to reliability, trust in outcomes and inference from big data, we think about things like the legal considerations, ethical considerations, and transparency. What did the owner of the data want? What if the subject comes up to you in your study and says, actually, I would love it if you shared my data. I would really like to help research. I have no problem with transparency and openness. I mean, yeah, I know there's some risks involved and you can maybe mix this with other data and there's discoverability, but I don't even care. This is very difficult for us to accommodate in our structure now. And there are other questions about whether it should be accommodated, but this is happening more and more where people in data, in studies, especially medical studies, would like their data to be more widely used than it actually is and would like less protection. What do you do with proprietary data in industry, or Facebook data, Google data, and so on? Vast troves of data. Think again about transparency, reproducibility, verification of findings that are based on these data that people can't get access to. It creates a real research dilemma. And then, as I've mentioned and other people have mentioned, making data available. Maybe this particular data set, you have some notion of consent from subjects. it seems like you could do some anonymization and so on, and then, as Helen gave many examples, that's not enough to maintain this going forward. Data sets can link this, profiles can be built, and so on. So, and we don't know how that will happen. And so even when you try to explain to someone, here are the risks involved, really, you don't even know the risks yourself as a researcher. Okay, so the main assertion is our traditional restrictions on data access for research purposes need to be revisited in the big data context to ensure replicable, reliable research results. Okay. Whoops. So what I wanted to do in the chapter is really highlight these two modes of thinking and how they come into conflict, and suggest that what we may want to do as researchers in the big data context is not consider this as a black and white as we traditionally have, data that's safe, data that's open, that I can make available, versus data that's closed. It has, proprietary interests. It has subjects in there that we cannot reveal any information about subjects and so on. But instead, think of this now as having a gray area in between where we can be more innovative about how we try to achieve goals of scientific investigation, including reproducibility, verification, and also take into account not just the legal considerations, but ethical considerations in protecting people who are interacting with studies or are the subject of studies. Couple of examples. Maybe we can think about, instead of just closing data sets that have privacy considerations or confidentiality considerations, we can establish, in some sense, what I call in the chapter walled gardens. So maybe we don't make the data fully open and available, and the code fully open and available, but what we do is we'll make it openly available to people that have been authorized into that particular walled garden. And so this is an example. For example, there are 5 universities in California that collaborate on neuroscience, where they're doing brain scans, and they can't just make this patient data openly available. However, they can do independent research as one lab in the 5, and then the other labs can independently access, because there are these controlled in the walled garden. They have been authorized in, they've gone through the protocol and so on. And then that gives some measure of independent reproducibility and reliability. Of course, it's not the same as having many more eyes catching mistakes in the work and so on. But this is much better than a single lab producing a result, or a single researcher and saying, believe me. Another example is data lakes. So there's a report that was actually, I think Jake mentioned it actually, that came out last month, the big data report from the White House. And they talk about prototypical data lakes that they're sort of testing out. In these data lakes, they've put in 2 types of controls. So one is controls on different types of data and who can access and so on. So it's not just sort of one control on the whole lake or so on, sort of very differential levels of access and what's permissible and so on. And then there are also restrictions on the types of queries you can visit upon the data lake. So you're not going to sort of like eventually draw out all the information in the data. And so this was done, there were a consortia with different experts and so on to try and decide on these rules. And so that's another way that they're sort of trying to step into that middle ground between fully closed data and fully open data, which is our longstanding traditional paradigm. So for the researchers in the audience, or people who are associated with data that could have a research aspect to it or an inference aspect, I would encourage more innovation around that space between open and closed. How do we achieve some of the benefits of openness, like better science, better inference, reproducibility, if we can even sort of step a little bit in that direction while still respecting all the legal, ethical considerations that we need to respect around the data. I think that would move us a long way to making big data actionable and valuable, and us being able to trust the inference from big data. All right, I'll stop there and look forward to your questions.
Thank you, Victoria. And we have just a few minutes left, but I'd like to open it up for any questions. We have time for a couple questions if anyone wants to address the panelists.
Hi, Tazza Greenwood from MIT. and one of your co-authors. And the walled garden part of your chapter, we thought had a lot of resonance with some of Sandy Pentland's concepts on trust frameworks and trust networks, and the way that they're structured with some kind of agreement and some sort of common architecture, common expectations, and maybe predictable legal outcomes as well. Can you think of some examples of walled gardens that might be particularly good to look at as starting points to start to extrapolate to this big data environment?
So this is very much, at least in sort of the academic research sphere, it's still very much brand new thinking about how we do this. And I think many in academia, where we just sort of saw all that stuff about the credibility crisis and so on, we're still getting our minds around how do we make data available, how do we make code available. I think it's kind of the next step to think, okay, so there's more than just making it open or making it closed, and there are new paradigms to embrace. So, and it's just slow. So I don't have canonical examples with, sort of lovely terms of use explaining how they work. There are, like I mentioned, researchers in California at these 5 schools who are experimenting with ways that maybe they can share data. Academia in many ways is something of a funny animal. Like we are trying to do the best work that we can, but of course we're subject to incentives and other pressures in how we do our jobs. And so this is something that's just taking more time to really come about. It's simply because we're just not rewarded for creating these walled gardens and making sure all the work is reproducible. We're rewarded for sort of publications and so on. So, but people are thinking about this, and it's becoming something where I think what we'll see in the next year or two is when you do have sensitive data, or even potentially sensitive data, having a system of being able to sort of authorize other researchers in, I imagine, would be one of the predominant ways of garnering some of those benefits to reproducibility and transparency.
Peter Elias, University of Warwick, England. I've got a question about the reproducibility of research results and big data. It is fundamentally important as part of the scientific process to be able to reproduce results, to check them, and then to extend them. I think that's we recognise that's of basic importance. And in fact, the Royal Society in the UK, which is the UK's foremost scientific association, produced a report, Science as an Open Enterprise, which stressed this point entirely. But one of the problems that we have with big data is that quite often these data are dynamic, they're flow, they're coming through time. So you've got a big problem then with data archiving, data curation, data storage, and data retrieval. Has any thought being given around this in terms of the aspect of reproducibility?
Yeah, this is a hugely exciting opportunity for science. So the first thing that we need to get better at as scientists when we disclose our quantitative research is being able to say, this paper is linked to these data, and it's linked to this code that generated the results, and those are sort of very tight, persistent links. And what it's linked to is a snapshot of a particular data set. So this isn't a data set where someone with the best of intentions comes along and fixes some mistakes that came to light a year after publication. At that point in publication, we have a particular version of the data set, a particular version of the software, and they probably are full of mistakes, but then we sort of build on it, as you mentioned, and we fix these things, and we sort of do a better job. And so one of the things that's really exciting about sensor-based or streaming data is we can say snapshot the data wherever that analysis took place, so for that publication, and then more data can stream in, and perhaps we can redo the analysis as the data sets are updated and so on. We still have that version snapshot so that one published result is reproducible, but then we can do things like verify that result, like did it persist into the future, and were our predictions correct? So it actually opens the door, I think, to much better science. And you mentioned issues around warehousing and stewardship and so on, and they're very, very important in big data and non-trivial because everybody knows the cost of disks is like dramatically falling and so on. It's still really expensive. And so sort of having snapshotted data for every publication, as I'm outlining, is actually, it's non-trivial, and especially when we're working with very big data sets. It's non-trivial even how you would query a data set. I can't just copy it onto my laptop and start fooling around with it. So we're really thinking about, bringing the analysis to the data and so on, and how do we, there's sort of a whole new, I think, computational architecture that will be around how to make these queries how to do them well over time and how to verify them over time. So I think you're raising a whole host of issues that, that I think are opportunities for better science, but we do need to sort of get the undergirding in place.
There are other fields, not social science, that have wrestled with these issues and solved them successfully. Seismology, astronomy, high-energy physics come to mind, where there is as much effort put into curating, distributing, ensuring the integrity of the data as there is in gathering and analyzing the data itself.
We're just about out of time, but one more comment from Julie.
I wondered what Kathy and Helen might have to say. You made it very clear in both of your chapters that really the reason that the world has changed and we need to rethink the way in which we're doing data is that the old rules don't hold. But what I didn't pull out kind of out of your discussion is this whole notion of informed consent and anonymity has this old survey approach where you go and ask people for consent on what they're doing. And Kathy, you made this very clear in your FERPA and your HIPAA examples where there is someone there to give informed consent, but realistically, the data that are being thrown off just by walking down the street, there isn't a person who is going to provide data. The data custodian is no longer clear. Another difference with the statistical agencies is you don't have someone who is tasked with providing access to the data. So I don't even know how we think about that in the old context. I wondered whether you had comments on that.
Well, I guess partly I would say that I agree with you. In other words, I agree with you that thinking about it in the old context is not very workable. It's not working. And in the law, we're really struggling with this. Both in the Fourth Amendment context, we've had important Supreme Court opinions that were not majority opinions by Justice Sotomayor saying we have to change what we're doing here. So I think there are actually two aspects of that to me seem very important, and I'll just point them out without having any answer about what to do about them. One goes back to this idea of somebody there to consent, right? And this relates to Helen's point as well. One of the biggest issues here is not so much about is the way that data is so intertwined. And that relates to Helen's point, but I think it's even a broader one than that. You hear people say, well, people pay with their data for what they got, or they don't care about privacy, or they wouldn't give up this data. But that kind of thinking assumes that there's some kind of individualized transaction where it's even meaningful to say, what is the potential harm to me from giving up this piece of data? That doesn't make any sense when things are so intertwined, and you may be giving another piece of data over here and somebody else gave it over there. So that whole mindset, which really dominates our legal thinking, is just not workable. The other point relating back to Victoria's, what Victoria said that I think is really important to think about is a lot of this data is not coming from researchers who are collecting it carefully. It's coming from industry. And that, as much as privacy, is why it's not available for being reproducible and all of that kind of thing. And I think this issue and the potential conflict of interest that are involved in that is one that really has to be grappled with, and I think has received really insufficient attention. It's like, I think, it's almost like, wow, there's all this great data, and we don't want to upset that possibility by, being too critical about where it came from. And because that's the data that's going to be used to make the kinds of policy decisions, and be used by policymakers and by governments and so forth, who aren't going to really understand the statistics, and they're going to be using some third-party off-the-shelf software. That's a really important place to focus attention, I think.
Yeah, and I mean, agree with everything Kathy has said. One of the so our concerns are fairly focused on these two strategies that have been very highly touted in protecting privacy. And the conclusion we arrive at is that these are merely procedural approaches. And in fact, and what they've done in the past, take something like consent, is to load the burden onto the individual under this assumption, this mistaken assumption that this is your information and you have a right to control information about this. setting aside the fact that the information you release can actually affect your neighbor or your member of your family and so on. So we do question that underlying premise. But when we look at the biomedical sciences where informed consent has been used, what we're aware of is that informed consent is actually only this portion of everything else. There's a whole set of substantive standards and expectations that a doctor and a researcher are expected to live to. Whereas in the privacy arena, what's happened is that the whole relationship is controlled by this huge privacy policy. And so there's this enormous burden that's placed on the individual. And this is really the crux of what we are recommending, which is that it's time to stop thinking we can deal with these privacy problems in this purely procedural way. We have to address the data users and say, you actually need to persuade us that there are standards, there are expectations, there is value that you're bringing, besides the hand-wavy, look how much value we're bringing. And this is how far we're going to go and no further, as we do with biomedical researchers, with doctors and other kinds of clinicians. And that's the work that we need to do. And then we can relegate informed consent to the role that it's appropriate for.
Well, thank you very much. And this concludes our first panel discussion. Round of applause for our presenters.